So when a marriage comes to an end, the path to dissolution isn't always a straight line. In Islamic law, it's not just one single road. It's more like a big intersection with four really distinct pathways. And which path you go down all depends on who starts the process and how they do it. Let's walk through that map together. To the heart of it, to our central question. Within the framework of Islamic law, if a marriage has to end, what are the different options? What are the actual routes available for making that happen? We're going to explore this by breaking it down into those four pathways we talked about. First, divorce initiated by the husband. Then we'll look at the wife's role. After that, what happens with mutual consent. And finally, we'll see where the courts fit in. All right, let's kick things off with path one, divorce that's initiated by the husband. This whole process is generally known as talaq. But here's the thing. It's not just one simple act. The framework makes a really crucial distinction between methods that are approved and some that are, well, disapproved. So, right off the bat, talaq splits into two fundamentally different approaches. On one side, you've got Talaq-ul-Sunnat, which are the approved methods. These are very deliberate, they're procedural, they're time-based. And then on the other side, you have Talaq-ul-Biddat, the disapproved method, which is all about being sudden and irreversible. Okay, so let's zoom in on those approved methods for a second. Because even within this group, there's a kind of hierarchy. There's a version that's considered most proper, and then another one that's considered just proper. So the most proper method is called Talaq Ahsan. It's really designed to be a very thoughtful, deliberate process. Here's how it works. The husband makes one single pronouncement of divorce. That one statement kicks off a really crucial 3-month waiting period. And this is key. It's not final yet. The divorce can be taken back, it's revocable, at any point during this window. It only becomes binding after those 3 months pass without a reconciliation. And that waiting period, it has a specific name, Iddat. It's really important to understand. This isn't just a passive countdown. It is a mandatory built-in cooling-off period. It's specifically designed to be a window for reflection, for thought, and for potential reconciliation before anything becomes absolute. Now let's check out the second approved method, Talaq Hasan. This one is also time-based, but it has a different structure. It requires 3 separate pronouncements, spaced out over 3 months, so 1 each month. The divorce only becomes final and irrevocable after that third and final statement is made. Okay, so you have those deliberate, timed processes. Now we contrast them with the disapproved method, Talaq-ul-Biddat, which you probably heard of as triple talaq. The key difference here is just how abrupt it is. All 3 pronouncements are made at once in one single sitting, and this results in an immediate, irrevocable divorce. It completely bypasses any chance for reconciliation, which is exactly why it's considered sinful or even invalid in so many schools of Islamic law. So that covers what happens when the husband initiates. But what if the wife is the one who wants to end the marriage? Well, that brings us to path 2, a whole different process known as Khula. So how does Khula actually work? It's essentially a 3-step deal. First, the wife formally requests the divorce. Second, and this is important, the husband has to accept her request. And third, the wife provides some form of compensation, which very often means returning the mahr. That's the mandatory marriage gift she received from him when they got married. Looking at this comparison chart really makes the differences pop, right? With talaq, the husband initiates things with a pronouncement. With khula, the wife initiates with a request and compensation. And notice how the husband's role completely shifts. He goes from giving the divorce to accepting the divorce. And critically, unlike those approved forms of talaq, khula is irrevocable right from the get-go. But what if the decision isn't just one-sided? What happens when both people in the marriage agree that it's time to part ways? Well, that brings us to path 3, divorce by mutual consent, which is known as mubarat. This pathway is maybe the most straightforward of them all. Mubarat literally means releasing each other, and that's pretty much what it is. It's a mutual agreement to dissolve the marriage because both parties just want to be freed from the marital contract. They work out the terms together, and once they've agreed, the divorce is irrevocable. Simple as that. And finally, what happens when one person can't get consent from the other, but there are legitimate reasons to end the marriage? This is where an outside authority is needed, and that brings us to our 4th and final path, judicial dissolution. So this process is known as fasq and nikah. In this case, a wife can go to a qadi, or a judge, and petition to have the marriage dissolved, but it has to be based on specific grounds. The mind map here lists several of these, including things like cruelty, desertion, impotence, or a very formal mutual accusation of adultery, which is known as li'an. So, let's bring it all together for a quick recap. We've just walked through the 4 distinct pathways laid out in our source material. Divorce initiated by the husband through talaq, by the wife through khula, by a mutual agreement, mubarat, and through the courts with fasq and nikah. And all of that brings us to a final thought. You know, when we see these 4 very distinct routes, each with its own rules, its own initiators, and its own outcomes, it kind of begs a bigger question. What does a system with so many different pathways for dissolution tell us about how a legal framework thinks about the complexities of marriage? Maybe it shows an attempt to create a structure that can actually account for all the different circumstances that life can throw at us. And that is definitely something to think about.